Hi, good afternoon everyone. Today is October 5th, 2017. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly community conference call, which we have every other Thursday to answer questions and recurring questions, frequently asked questions from the community. Participating in this call does not create an attorney-client relationship, as is announced in the beginning of the conference as you log in. Let me begin with the frequently asked questions first. So one of the first frequently asked questions is, what are the current immigration visa options for entrepreneurs? As you folks might know, there was a rule announced by the Obama administration for entrepreneurs which was supposed to come into play, I think it was in July 2017. Then Trump administration moved in and had that rule postponed to March 2018, I think. They have a lawsuit now against that action, that basically government cannot delay rules like that, and that is a violation of a law called Administrative Procedures Act. That hearing, as I recall, I'm speaking from memory, is scheduled for October 20th. So until that hearing is held and a decision made, we don't know what the status of the entrepreneurs rule is going to be. Government does have a lot of leeway in juggling with regulations, but if they want to outright cancel, I guess that's the best word I can think of, cancel or replace a regulation, they have to go through the rulemaking process again, which basically means going through the entire government process, including publication, notice, comment, and the final rule. So the entrepreneur rule is being challenged, or the delay is being challenged as violative of Administrative Procedures Act. While that is going on, are there any other options? Well, EB-5 for green card, but that takes too long. That's a 2, 3, 4 year long process. You will not be able to start your business. O-1, if you are an extraordinarily well-known businessman, somebody who has sustained national or international acclaim, you could start with an O-1 probably. Basically, have your own company employ you and process your O-1. If you are from one of the countries where there is a treaty between that country and USA, you could look at E-2 visa. If you're a Canadian, you could look at TN visa. You could also look at an H-1 through your own company. It can be done as long as there is an employer-employee relationship. So entrepreneurs will have these options, as I just discussed: come in on an E visa, an H visa, an O visa, or a TN visa, and eventually get a green card based upon various other options, including EB-1A if you're an extraordinarily qualified individual, or an EB-5 if you are making the required amount of investment and creating the jobs necessary under the rules. I'm trying to make this as comprehensive as possible, but if you want a more detailed discussion, we might have to set up a half an hour just to go over the various rules. And last but not the least, my favorite, which is the L-1A. If you have a foreign company, you have worked outside for that company for at least 1 year as an executive or managerial employee, you can start a company or buy a company in the United States and transfer yourself or your key managerial employees or employee to USA It's the fastest way of getting a green card because L1 is potentially processed within a few weeks because you can file it premium processing. And once you're here, you can file an EB1C based green card, which will get you seen through the process normally within a year, sometimes as little as 3, 4, 5 months. So let's run over the options again. Treaty trader, treaty investor, these are countries that have treaties with the United States. India does not. Pakistan does have an E2 treaty. Many European countries have E2 treaties. So E2 would be one option. E1, treaty trader, E2, treaty investor. Canada certainly has that option available, citizens of Canada. Then you have the H-1 visa option where you can have your own company sponsor your own case. Then you have the O visa option if you're an extraordinarily qualified individual who's supposed to be at the very cutting edge of your or top of your profession. By the way, we have received a lot of almost, I think, a bunch of EB1A approvals in technology and business. So SAP people, Agile, knowledgeable Agile certified managers. We've received a bunch of approvals, so it's certainly worth looking at if you have a case to see if you can get an EB1A/O1. O1 is kind of the little brother of EB1A, where you can get into the United States relatively quickly. Okay, but I do want to, if there is interest in that, I can do a separate conference for that, maybe even a Skype call and go over everybody's questions. I've done that before. I think we have some information now, frequently asked questions. But the landscape of the laws keeps changing, so it may be worth our whiles to do a separate call for that. Anybody has any question about entrepreneurial visa options, press *5. Anybody has any questions about entrepreneurial visa options, press *5. If you guys want me to do a separate call, you can send me an email to help@immigration.com. Okay, help@immigration.com. Let's go on to the next frequently asked question. This one, let's see. Bear with me a moment. I'm actually off-site today. Yes, this one actually also deals, and this might be of interest to many people, the H-4 EAD litigation lawsuit, what's going on. And IMMYAssist asks me, what is the latest news regarding H-4 EAD? I understand that DHS has asked for abeyance until 30th December. I think it's 31st December. While they are evaluating the H-4 EAD rule in accordance with the Buy American, Hire American executive order. And DHS will refocus its review of the H-4 rule to ensure that it meets the newly announced priorities. So should they be doing a new rule? So this member of our community wants me to explain in layperson's terms what will happen with the H-4 EAD holders. Okay, now, right now, let me explain to you what the government has asked. Government has said, look, Your Honor, this lawsuit pertains to regulations that may not be relevant because government may decide to overrule these regulations with some new regulations. What would those new regulations state? We don't know yet. We have to review. The possibilities are several. We could end up modifying the rule, narrowing it. We could end up totally rescinding that rule. And of course, if you have to rescind a regulation, I don't know of any way of doing it other than going through the rule-making process again. So that would probably take a few months. And my guess would be, in order to keep the exit from the regulations, if there is indeed an exit, orderly, government will probably provide some months grace period for closure on the H-4 EADs. So right now, that's what we know. Unfortunately, Trump administration has been the most chaotic administration in every field, including immigration. It is absolutely horrendous to see a first world country being run worse than a developing nation or a banana republic. But that's where we are. Those are the times that we live in. There's no certainty what the government is going to do, but whatever they do, it's not going to happen overnight. Press *5 if you have a follow-up question. *5 if you have a follow-up question. Okay, I'm going to move on to the next frequently asked question. And this is asked quite a bit as well. What are the consequences of a denial of entry at the airport? When you come to the airport and let's say they find in your documentation something objectionable, or they find that you have a document missing, government can do one of the following things. They can allow you limited entry, which says, okay, you've got only a week's stay in the United States and you can't extend that status or change status. Or they can formally deny you entry, which has the consequence of disallowing entry for the next 5 years. That's a 5-year bar if they formally decline admission or exclude you at the airport. Third, which is usually the most common thing government does, they allow you to withdraw your request for admission, which then has no consequence by itself. So you have to go back from the airport, but it doesn't have any 5-year bar or anything associated with it. Vianney says, I had been traveling to the US on tourist visa, but in 2008, they found a pay stub. So they made me sign what looked like a voluntary departure or refusal of entry. See, these are two different things. If they allowed you to withdraw your admission, you would have no black mark. But even if you did, that was back in 2008, so more than 5 years are over. So questions are, is there a website where I can see if I was penalized? And the answer is, well, you can file a Freedom of Information Act request with Department of Homeland Security and or Customs and Border Protection and or USCIS and see what information they have on you. Within a few months, they should be able to give you a copy of your documents, everything that they have on you. And this doesn't cost you anything. Can you get another tourist visa? I think it's more than 5 years already. So as far as the consequences of that declination or refusal of admission, whether it was a formal exclusion or allowing you to withdraw your application for admission, that time is long gone. But do remember, a tourist visa is not a guarantee. It is a discretionary visa. The consular officer could refuse you a tourist visa for 10,000 reasons. So even if the fact that you worked without authorization on a previous time is long gone, the prior bad history could be used to deny you another tourist visa. Would it be a waste of money to try? As long as you don't lie about anything, by all means try. Only if you make a misrepresentation or try to conceal a material fact, you would have long-standing problems. Your father is a US citizen, can he request citizenship? No, you have to go through green card, and it takes many, many years. So if you go to the visa bulletin, it's on our website, on State Department website, there's a category for unmarried children of US citizens, and it takes several years. It's not a very fast category. Okay, *5 if you have a follow-up question on this. *5 if there's a follow-up question on this. Okay, let's see if there's another frequently asked question. No. All right, now we're gonna go in series one by one. So I have merged two questions in the next one. They were close to each other. So the first part was, I am on H1, my wife joined me on H4, then changed to H1. Her H1 renewal is pending. They've applied for extension. So can we apply for an H4 alongside H1 extension? And the answer is yes, but there are some issues that you need to be aware of. First of all, if an extension request is pending and her prior H1 has expired, they won't adjudicate the H1 or the H4 for her until the prior pending status is also adjudicated. So if on the date her H4 is decided, H1 is pending or denied, she'll have to go outside USA to get her H4 and come back. So it can be done, but if there's a pending status and there's a gap in the status, they won't approve within United States. So look into, you can Google this information. This status between two authorized statuses is called authorized period of stay. So there are three ways of approaching status. One is to be fully in status. You are in H1 or H4. The other one is to be unlawfully present. Your I-94 has expired, nothing is pending. And the third, which is your case, your wife's case, is that an extension is pending, old status has expired. She is in what is called authorized period of stay. Authorized period of stay is not full status, but it is legal to stay in the United States. You can't go from authorized period of stay to another status until the prior pending application is adjudicated. You are put back into status. In order to go from one status to another, you have to be in status. You cannot be in application pending status, which is authorized period of stay. So you can always withdraw an H4 application by just sending a letter. So if you have an application pending, you can always withdraw it. Can you apply for an EAD at the same time as an H4? The answer is yes, of course. *5 if you have a follow-up question on this, *5. The second question that I merged into this was similar. So this one said H1B to H4 change of status is pending July 14th. Spouse's H1B is expiring on November 2nd. Can I apply for H4 extension? Should I mention it as the current non-immigrant status H1 or H4? So H1 to H4 change of status is pending as of July 14th. H1 is expiring on November 2nd. So after November 2nd, she would be in authorized period of stay because she has a timely filed change of status pending. Can you apply for an H4 extension? Yes, you can. And don't worry about, I can't help you fill the forms, but the status in between statuses is called authorized period of stay. Will it be okay to apply for H4 extension after it gets approved? So that depends. How long did you ask for in the H4 application? So let's say the H4 is expiring. You asked for H4 extension till December 31st. Now, come December 25th, the applications are still pending. It would be absolutely required that you file another extension before the extension that you asked for that has not been adjudicated is still pending expires. So you have to have a bridge between one application and another. Just remember that. If the change of status is approved after the requested date, what will be the I-94 date? November 30th or November 2nd, I'm sorry. That's the reason you need to file another extension application. *5 if you have a follow-up question. *5, okay. Let's see. Like I said, I'm not on site right now, so I'm having a little bit of time, a little bit of a trouble keeping track of all these questions. Let's see. Let's start with New Jersey. New Jersey, go ahead. I can hear you.
Hello, Rajiv ji, I have a question very similar to what you were speaking about.
Sure.
This is about an employee in my company. His wife came to the US. She had a stamped visa until 2020.
Okay.
When she was at the port of entry, on her I-94, they gave her only until May 2018 because that's until when her passport at that time was valid.
Okay.
So she came in over here, she got a new passport, and now she wants to apply for an H-4 extension because she feels that her I-94 is expiring. She doesn't want to leave the country and come back. So is there anything that we can do that can ensure that just her I-94 is extended instead of having to file an extension for her?
Let's see for a second. Do you know on the date when she entered and she got a shorter I-94, was her passport valid for more than 6 months?
Yes.
I think it's worth approaching the Customs and Border Protection. CBP has hours, local hours. You can go to their website and see if you can get into one of their offices locally. They have them at all the airports actually. To discuss with them. Yes.
I think they tried speaking to them over the phone, and they were told that because they would make corrections if they made a mistake, and they would correct it. But because it wasn't a mistake on their part, and for that reason, they said that they wouldn't be able to take care of it.
You should have them go and visit a CBP office, see if they can talk with somebody there personally. It looks like it could be an error because I don't think it is a requirement. Now, I am a little hazy on the exact requirement. We know for sure that your your passport must be valid for at least 6 months or more on the date you enter the USA. But India does have an exception with the US government. That means they'll allow you to enter, but they'll give you shorter duration I-94. Now, what if my H-4 is good for 3 years, but my passport is expiring in 1 year? So should they give me I-94 for only 1 year, or should they give it all the way to 3 years? I'm a little hazy about that. I don't remember exactly what the law says. It is there on the CBP website in the frequently asked questions. If indeed the law would allow them to give you an I-94 going all the way to 3 years, you should ask for it. If you don't ask for it, you have only 2 options. Either go outside USA and come back, you get another I-94, or apply for an H-4 extension within the United States, which is what your employee wants to do. Those are the only 2 options.
Okay. Thank you so much, Rajiv.
You're welcome. Good luck, ma'am.
Thank you.
Okay, let's I'm still struggling with this, so give me a moment. Next one, we have 2 more questions. Next one is from Illinois. Illinois, go ahead. I can hear you.
Yeah, hello Rajiv. This is regarding the second part of the question.
Yes, sir.
So, as far as I understand, so as you are saying that I can apply for an H-4 extension even though the change of status is pending, right?
Right.
Right. Okay, with the notification. So my question, another question here is, can I leave the country anywhere during this change of status and go for an H-4 stamping directly?
Absolutely.
To avoid all this
Absolutely. And it causes you no harm, even though the pending H-4 is considered to be abandoned. But we don't really care about that because we are going to come back with a new H-4 visa stamping that will take care of everything.
Okay, but so that won't put my status, I mean, my situation as out of status starting July 14th, right?
Not at all. No worries at all.
And is it okay if I travel after November 2nd, or it's no?
No, you can't travel because you have, you can. I mean, if you're going to go for visa stamping, But if you're gonna, if you want to go for visa stamping, you can travel after November 2nd as well. But remember,
even though I have requested my H4 status only till November 2nd.
Yeah, because unlawful presence will begin on November 3rd or November 2nd, and after 180 days, you would become probably subject to the 3-year bar. Also, I don't like in this environment being out of status and unlawfully present even for a day, because technically you become deportable. And if government wants to deport you, they can try. And if they do manage to deport you, you can't come back for 5 years. So I just don't like the idea of putting myself at the mercy of this very draconian government. I would leave before November 2nd if I'm going to leave. But if you file an extension, then you can leave anytime during that extension.
Okay. Thank you, sir.
Oh, you're welcome. Alrighty. Skip this, mute this. Now let's go to California. Okay, California, go ahead, please.
Yeah, so just I want to give my experience on the I-94 expiration. So
Yes,
for my wife, I-94 has expired, and even though like L2 visa is valid, so due to the passport issues, so we went to like San Diego, there's a Mexico border. There it's simply like we paid a $6 fee, and we are not crossed even border. So just they took like, and we went in the line, and they took like fingerprints and photo and everything, and they given I-94 until my visa valid.
Yeah, I've heard of that before. Thank you for sharing that with everyone. So what this gentleman is saying is, he's in California. When they had the I-94 type of issue, they just went to the US-Mexico border, paid a fees of about $6, stood in line, got their biometrics done, didn't have to go to Mexico, still got the H-4 I-94 extended right at the border itself. Correct? Is that what you did?
Oh yes, it is not expired, it is on L2, but the
L2, same idea. Same idea. It's a derivative, so yeah. H4 and L2 has no difference in this regard. Thank you so much for sharing that. I was vaguely familiar with that too, and it's good to know that that's also an option. I'm not sure if that option is being also exercised at the Canada border. It should be the same rule everywhere, but I don't know firsthand whether that is true or not. Okay. Any questions or comments, sir?
Yeah, nothing from my side. Thank you.
Okay, thank you. Thank you for sharing. Bye-bye. Okay, let's, I think we are done with questions on this. Let me run through this. Yeah, we're done. Okay, let's go on to the next one. And this one is actually quite disturbing, but that's how it is. Nick, H-1B, says, they approved my H-1B transfer, then a month later they sent an RFE. Is it valid? Do they have the right to do this? Yes. They have the right to do, to send a notice of intent to deny or revoke anytime they want, and an RFE too, if they discover that they had made some error. They shouldn't be allowed to do it, but I don't think there's anything illegal about it. It's highly, you can call it immoral or disturbing, but it's not illegal. So not much you can do about it, really. *5 if you have a follow-up question. *5. Okay, let's go on to the question number 5. I'm in the US on EAD Advance Parole based upon a pending I-485 employment based. I last entered in Jan 2017, so my I-94 is expiring. Now, you don't have to worry about that I-94. Even past the I-94 that you get with the Advance Parole, you can continue to stay in the USA because your 485 is pending. So you really don't have to do anything to extend your I-94 under these circumstances. *5 if you have a follow-up question. *5. Press *5 on your phone if you have a follow-up question. Okay, let's go on to the question number 6. H-1B extension. Currently in the 9th year of H-1B on the basis of an approved I-140 EB2, Priority date, October 2015. Now my job title is changing from principal engineer to project manager, but there's not much change in the job description. I have to look this up for a client of ours who is also in a similar situation. He is going from a senior web developer to director of technology. We've already finished his I-140, POM-based I-140. So I'm going to review the regulations. I think I should be able to do it this week, and I know Saturday I'm busy. So probably Sunday I'll spend an hour or so. Review the regulations. Something I remember vaguely that the January 17th regulations had something about, I know that for 485 it's no problem. Jobs just have to be same or similar when the 485 has been pending 180 days. But does that rule also save us before the 485 is filed? I think there is something in the regulations on it. I don't know off the top of my head. Okay, so if there's not too much difference in the two jobs, just the title, I think you should be okay with just the you shouldn't have to do an H1 amendment. What effect it has on green card? Have your lawyers review the January 17th regulations. Okay. How is the title same or similar computed? It is based upon the standard occupational classification, as well as, remember, even if the jobs are related, I think a good rule to remember is this. A job is same or similar. Let's say there are two jobs, job 1 and job 2. You used to be working on job 1, you went to job 2. If training in job 1 prepares you for job 2, that's an example of same or similar. If both job 1 and job 2 require similar type of training, that's another example. So one is a subset of another or superset of another, or the two are subsets or supersets of another job. Kind of like that would be same or similar. So in the technology industry, let's say you are a systems analyst and you become a system architect who's doing system design, etc. I think that's okay because it's one job can train you for the other. It's the same if you were a programmer or a programmer analyst and you became a software engineer, software developer, or system architect, because one job prepares you for the other. It could be also if you went from being a software developer to a QA lead. If you are a software developer, it can prepare you. It does prepare you to be a QA lead as well. So it all depends on what the particular circumstances of your case are. But they do look at the standard occupational classifications as well as other factors that point to the relationship between the two jobs. Star 5, if you have a follow-up question, star 5. Okay. Let's go on to the next one. Arpana says, my husband is on H1. It's an abusive situation. I was not aware of this because we don't do a lot of VAWA cases, Violence Against Women Act. You should look into it. Violence Against Women Act protects H4 people too. It didn't used to. Rather, relatively recently, it has started protecting even H4 holders. Look into that. Previously, it used to be that the abuser has to be a green card holder or a US citizen for the abused to be sheltered under Violence Against Women Act. But now, even if the perpetrator of the violence, your husband, is H1, and violence doesn't mean just necessarily physical, it can be mental as well. So you can take a look at VAWA protections for spouses of H1 holders. Certainly worth looking into. Star 5 if you have a follow-up question. Star 5. Okay. So we go on to the next question from Alex Faust. Alex says, I'm an American, wife has a green card, want to apply for her daughter. She was 5-year-old and living with us when we got married in Taiwan about 4 years ago. In this case, either one of you can apply, but I think applying through you would be faster, especially if you consider her to be your child and either legally adopted her or consider her to be your child before she turned 14, which is true for your case. I don't remember all the details of the law, but something like that. So you have an option of applying through yourself or have your wife applying, because the definition of child of a U.S. citizen includes a stepchild. As long as it was before 14 and you acknowledge her as your child, you can certainly apply for her. It will be a lot faster, I think. I don't remember the dates off the top of my head. But if mom applies, who's a green card holder, and a stepdad applies, who's a U.S. citizen, chances are the stepdad process is a lot faster. *5 if you have a follow-up question. And it's the Form I-130 that you need to look at. That is correct. Okay. *5. No follow-up question. Okay, let's go on to the next one. This one is Sabarish SP. This is about the the level 1 request for evidence. So question is, can I refile my LCA to wage level 2? I don't think so. Any actions you take after the filing of the green card are not likely to be acknowledged and accepted by the government. How do I respond to the RFE? It all depends upon the case. Very, very difficult to make general rules. But every job must be examined in its own context. I'll give you an example. Government has this argument that if a job is an entry-level job, then it is not complex enough to be a professional job. That is the dumbest thing I've ever heard. Why? Let's look at the case of, let's say, just a hypothetical of a neurosurgeon. Our neurosurgeon, Sam, goes through, let's say, Sam has 4 years of college. Then 4 or 5 years of med school, 9 years. Then 5 years of surgery residency, 14 years. Then another 5 years or 6 years of neurosurgery. And that's almost 20 years of extremely rigorous training. When he leaves his job, when Sam starts his own practice, he's still an entry-level neurosurgeon. But that doesn't mean that just because he's an entry-level neurosurgeon, he's not a professional. So each job must be considered in its own context. What should you do if you get denied? Well, we have not filed, I think out of many H1s we did, maybe we did 2 or 3 level 1 filings, because we've been expecting this issue for years and cautioning clients that entry level is reserved for only those positions where the person is still learning the job. They are a professional, they've got a degree, but they don't have yet the hands-on experience that is necessary for more experienced jobs. So I can't really answer your question as to what you should do. That depends upon your particular case and the facts of your case. But the argument would, of course, be that your case involves a professional who's at entry level, not somebody who is a non-professional. So a distinction must be made between an entry-level person who's a professional and a person who's non-professional. One does not equal the other automatically. *5 if you have a follow-up question. *5. Okay. Let's go to Raju for tech. I'm on L1B visa. Company applied for H-1B counselor processing. I got picked in the random lottery. I need to go for visa interview and come back with visa stamp. They want to start my green card. If green card processing starts before my H1 visa interview, is there any issue for my H-1B visa? Not at all. Start your green card as quickly as possible, even though you don't have an H-1 visa yet. What is the best case scenario for green card processing after getting my H-1B visa? I don't know what you mean by best case scenario. If you're in EB2, look at the priority date. Approximately that is your best case scenario. If you're EB3, again look at the priority date in the visa bulletin. That too is approximately your best case scenario. On H-1B approved petition, it is addressed to Chennai. Is it mandatory to take an appointment at Chennai? No, you can take an appointment anywhere. Not only in India, but any consulate anywhere in the world. Star 5 if you have a follow-up question. Star 5. Okay. April Wilson says, planning to apply for US citizenship, came to USA. So there was a year where we did not file a tax return because we had income below tax filing. I don't see any problem with that. You should certainly add a letter explaining to the government that taxes were not filed because the income was less than the taxable level. I don't think that should be an issue. Star 5 if you have a follow-up question. Star 5. Income below tax filing threshold is just bank interest income on fixed deposit. It was not W-2 of self-employment income. Yeah, okay. As long as you were not required legally to file a tax return and then you did not file one, it is not a problem. Next question is from Prasad 99. I'm on H-1B. My I-140 is approved a year ago with my current employer, but my employer did not share a single I-140 related document. So, based upon the Freedom of Information Act request, you got it from USCIS National Record Center. USCIS National Record Center approved, provided you approved PERM, but they don't have any record of an I-140 approval. Well, I don't know what's going on here, because if they don't have a record of your I-140 approval, there are only two possibilities. One, it was never approved, and two, it was approved and then revoked. But even then they should have a record. And there is a third possibility, which is unlikely, but government could make a mistake too. They just may not have the approval. So I can't really answer your question about further H-1 extensions, because if an I-140 was not filed within 180 days of approval of the labor certification, then you have lost that PERM application and you don't have any right to extend your H-1 beyond 6 years. So I don't know, this is a very odd situation. I think you should contact the old employer and their lawyers and see if you can get a copy of the I-140 approval. And also if you can get a date on which the I-140 revocation was requested, if it was requested and approved. Star 5 if you have a follow-up question. Okay, let's go on to the next one. This is from Hirsch 14. I'm an H-1B, approved I-140 from my previous 2 employers. Wife is working on H-4 EAD. I lost my job. Well, look, in order for your wife to maintain her H-4 EAD, she must maintain her H-4. In order for her to maintain her H-4, you must be maintaining your H-1. Any part of these logical series fails, she does not have an EAD. Okay. So if you are out of a job, theoretically at least, you've got a 60 days grace period to look for a job and apply for another H-1. But if you are not able to do that, then you're definitely out of status, and so is your wife. You don't need to take any additional actions. The grace period is 60 days or expiration of the I-94, whichever date is earlier. Star 5 if you have a follow-up question. Star 5. Press star 5 on your phone. Okay. Let's go on to the question number 16. You will need to apply for an extension again if your last issued I-94 or the most recently issued I-94 is for a lesser duration than the original approval. So you have to get an extension. If it is a mistake by Customs and Border Protection, as I was discussing earlier, you can contact them and try to get it corrected, the I-94. But if it is not, You have two options. Either if your visa is still good, go outside, come back using that same visa, or apply for an extension of your H-1. And of course, the gentleman who was on the phone talked about going to California-Mexico border. I don't know where you are located, whatever the convenient border is. You can contact CBP there and see if they have a procedure for extending your I-94 by paying that $6 fees that that gentleman talked about. *5 if you have a follow-up question. Okay, so basically your options are extending the I-94 through an extension or through the border. Okay, no question on this. Let's go on to question number 18. So kindly explain the next step on H-4 EAD and timeline in each step. My case, on H-4 EAD since 2012. Before that, I was on a cap-exempt H-1B. I-140 is approved, but didn't file 485 since I moved to current H-4 EAD. Okay, at a different location. Now I want to return to the old job and apply H-1B again. Sure. If returning on current H-4 EAD, how do I transition to new EAD based upon the above application? You can use the same H-4 EAD. You don't have to change your H-4 EAD. Once you are converted to H-1, then you automatically lost your H-4 EAD. See, as long as your spouse is maintaining their H-1, the fact that you're moving from employer to employer, H-4 EAD is good. Don't have to do anything with that. To reinstate your H-1B and the timeline, look, if you were on a cap-exempt H-1, you have to go to a cap-exempt H-1 again, apply premium processing to be reinserted into the H-1 status. And you cannot file 485 until government tells you, based upon either the visa bulletin or if the visa bulletin refers you to USCIS, based upon USCIS notification. So what should you do? Not sure I can give you very good suggestions on this. Return to, just get your H-1 done. I think that would be a good thing to do. And of course, file your 485 as quickly as you can. *5 if you have a follow-up question, press *5 on your phone. Okay, let's go to Manti, our last posted question of the day. And then we'll start with new questions if there are any new questions. We have about 15 minutes time left. So Manti says, oh wait, yeah, that's the last question. Question on H-1B transfer. Employer A filed for my H-1B transfer. I joined employer A on getting the receipt. RFE has been sent. We don't know what the reasons are. So I know I have to leave if I get denied. If I do have H-1B visa stamping, can employer A refile the petition? Actually, USCIS has recently said, there's a memo out there that says, if you join employer B based upon the receipt, and that petition is denied, you can go right back and start working for employer A without any additional filing, as long as employer A has not revoked their H-1, and as long as that H-1 is not already over. So you could actually go right back without doing anything extra. If a new employer C files for H-1B transfer now, and then ongoing petition by A gets denied, A or B? Okay, do I have to leave USA? Provided I haven't joined C, you can join employer C directly. See, all depends. I think this is too complicated for me to comment in generic level, at a generic level. The way it works is, as I explained earlier, if you are in status, you can be hopping from employer to employer without any problem. But if you're in between statuses, things get a little bit more murky. You should have your lawyers help you parse through and understand your particular situation. And about the level 1 wages, I've already discussed that earlier. a little bit further up in this discussion, about 15-20 minutes ago, that it all depends upon your particular case. Just because it's level 1 doesn't mean it's automatically going to get denied. You've got to present your side of the fact that this is a professional job. *5 if you have a follow-up question. Okay, we have about 10 minutes. Let's do any new questions you might have. Press *5 if you have any question. Press *5. 1, 2, 3. Okay, we have 3 questions. Let's begin with Illinois. Illinois, go ahead. I can hear you.
Hi. My husband had posted one question, her 14. I had a follow-up but couldn't get at that time. So the question is that if he lost his job, right? So during 60 days, he still maintain. I mean, he will be still considered in H-1 status, right? So I can still have still work on my H-4 EAD. Is that understanding correct?
I believe so, ma'am. I do believe so.
Okay, thank you.
Okay, you're welcome. Good luck, ma'am.
Thanks a lot.
My pleasure. Okay, let's go on to California, and the next one is Connecticut, last one. Let's go to California. Go ahead, please. California.
Hi, sir. This is regarding question number 10. So just my H1 is approved under council process. So October 3rd or 4th, it was like premium processing is allowed. So is there a way for me to get like approved and apply for the change of status for the H1,
You can, Raj, but you have to basically redo the whole case. The change of status for an H1 is not like the change of status for other visas. For H1 change of status, you actually have to refile the entire paperwork all over again, and the government can reopen your whole case and look at it again. But if you have a good case, by all means, go ahead. And now there is premium processing. Yeah, you can do it. No problem.
So my L1B is valid until like December. So I think like if it is the premium processing, maybe like it's in 1 month it may complete, right?
1.5 months. Yeah, and as long as you get it filed before December, before your current L1 expires, even after L1 expires, you can stay and wait for the adjudication of the change of status.
Oh, okay. Thank you so much, Ravi.
You're welcome. Good luck. And that period is called authorized period of stay. All right. Bye-bye. Let's go on to the last question for the day. And this one is from Connecticut. Connecticut, go ahead, please.
Hello, Rajiv. Good afternoon. This is Anish here.
Jinishi.
Yeah. Actually, I'm calling regarding currently my company, they are moving to a new facility from in the New Jersey itself, from New Jersey one location to another. But in the new facility, they are starting the hoteling system where not everybody needs to come to the office every day. Only need basis you visit the office. There won't be any desk allocated to anyone. You book your seat and come.
Sure.
So in my case, like I am on H1B, my firm case is also pending 140 already approved. And when we move to the new location, so my manager has given us the option to make our location as a home office location, and then just visit the new facility whenever need arises. Does it impact anywhere in H1 or firm process?
That's a difficult decision for me to make, sir, because there are two aspects to this. One is, does it impact the H1? That's the first thing we would like to know. So for that, we have to figure out whether the job is within normal commuting distance, which means in this case your home and your earlier job. And if it is, then we probably don't have to do an H-1B amendment. But if you live very far away from your job location for which the LCA was approved, you might have to do an H-1B amendment. Is that part clear?
Yeah, correct. I mean, whether it's commutable every day, if it is
right,
possible.
right. And
so yeah,
then
if I hold the commutable, even the new location will be commutable.
So then it should be okay. And the second element is about the green card. Now, I don't know how the green card was filed. If the green card was filed as travel and relocation required or possible, it's a different mindset and different set of rules we have to play by. But if it is filed as an out-and-out location in the corporate headquarters, so your lawyer should look at it. I don't think it's going to be a problem, but it's important enough so that you should get to somebody who's representing you and your company, get them to take a look at the entire set of facts just to make sure there isn't anything here that could come back and hurt you tomorrow. Personally, I think there's 10,000 solutions to various issues that you can potentially find, but I can't really comment without knowing your case. So somebody has to review your perm, somebody has to review what the corporate direction is. As long as everything is within the normal commuting distance, you should be fine.
Oh, thank you.
Oh, you're welcome. Good luck. Okay, everyone. This was, as usual, always great to see you all, talk to you all. We'll see you again in 2 weeks. I feel very privileged that I can help you, assist you in answering all your questions. Take care, folks. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.